One final word on contingent employees. You really want to make certain that you have contingent employees and what their status is. If you ever have a situation where you walk into an organization, you need to just go back and just kind of refresh yourself as to who each individual is and what their employment status is. It won't take all that long, and it might save you an awful lot of time and pain later on. If you walk in realizing a couple things, the gig workforce, these temporary employees, contingent employees, whatever term you want to use, pay attention to that aspect as to what exactly are they? Are they an employee? Are they this? Are they that? Know what they are, because if you don't, all of a sudden you may be caught flat-footed in the process when somebody sits there and files a complaint with the IRS and all of a sudden they become an employee. You don't want to have that happen. Interns, you have to pay attention to some of the other aspects of what is a primary beneficial test. Look at the different aspect of what the FLSA rules are. There's a lot of enforcement there. Sometimes if you have a volunteer, they could be unpaid, but they may work themselves into saying, but I worked this over here. They told me what hours to work. Pay attention to the aspect and be clear, even if you have to provide them with a letter identifying exactly their relationship within the organization. That might help in the aspect. So look on that. Staffing firms can be an interesting help to you, but make certain that the contract language is clear as to who exactly what they are. You might hire a staffing firm that provides you with an administrative assistant that works with you for 1 year underneath the contract, and all of a sudden that person then files a claim saying they're actually an employee of yours because the contract was sloppy or somebody wasn't paying attention or whatever the process. If they're paid by an agency, who provides the training for that person to do the job? If you provide it, is it clear that there's a training period identified in the contract? Make certain that who provides workers' compensation coverage. If you provide the training, you provide workers' compensation, it looks more and more like they're an employee and you're just having to sit down and have them go around your payroll system by paying somebody else. Know about the staffing agency or who bears what employment costs there are, and have that in writing, and don't have anything gray or I trust them. It doesn't float it when the IRS comes knocking on your door and you're the one sitting in the chair perspiring because they're asking you some very specific questions. There's 6 factors. Training, who provides it? Who has the ability to hire and fire? If you fire a temporary worker, okay, and the person next to them sees that, all of a sudden now that you fired them, you need to call the agency and have the agency fire them because they don't meet the qualifications that you want. Who supervises them? Okay, be specific on that. And then the location, how long has the assignment been going on? Oh, it's been going on for 3 years. Okay, all of a sudden now this temporary agency looks more and more like they're doing an end run around a payroll system. Make certain the contract is clear. Third-party liability, make certain that the client discriminates illegally, that they're held accountable for that, and you don't pick up that aspect either. So look at all the different aspects underneath the applicant protection aspects of it. You don't want to be sit there caught flat-footed by the Office of Federal Contract Compliance, especially if you have a federal grant. If you have a federal grant for more than $50,000, you have to watch what their rules are as well, and that really is not the scope of our class here, except now it is. So workers who seek employment are protected from discrimination. Make certain that that is in the rules you have with any kind of contractor. Pretty much, here's how it works. A person submits an expression of interest for an opportunity, employer considers him, the person possesses qualifications, the person doesn't remove themselves from consideration, and you turn around and hire the same employee for a similar job in your organization through a staffing agency. More and more, it looks like you're doing an end run around the rules from the IRS. You could have a serious problem. IRS rules, well, maybe too much. The rules, the 19 different steps they have, are critical in determining if a person is a contractor employee. Contractors, they prefer to avoid a long-term commitment. Soon as you go long-term, all of a sudden they look more and more like an employee. Contingent workers are a way around hiring. Now, here's a real scenario in the aspect of you have somebody that you've hired as a temp. They're a temp employee, whether they're a contractor or they're actually a temporary employee. They work with you for 7 months. You like the work they do. They fit in. They have this great personality. And then you post a job that has exactly the same duties, and miraculously, you hire that person. When did you hire them? Did you hire them 7 months before and just kind of cheat the system in the process? Okay, did you hire them 7 months before and have them go through and give you a tryout for 7 months? I'm not certain that could be considered illegal. It's just, are you sitting or complying within the rules of the Internal Revenue Service? So pay attention to what you're doing. If you have a hiring policy and you have a way of applying that, make certain that you're paying attention and following the policy and not following the whims of your heart. Because when it comes to the IRS, when it comes to employment law, the heart doesn't have a place. The law has a place, and that's where you'll be held accountable. So make certain that you don't make an error in determination. A couple things. Here are some of the tips about a worker status to look for. Who pays taxes, expenses, materials, and tools for that worker? What is preferable to pay independent contractor for results, which is what you pay them for rather than the time. If you're paying them for the time to be there, sometimes that's very important. Okay, or you're paying for the results. Results, contractor, time, sounds like an employee. Employer provided training. It's an indication of employee status. If you require everybody to go to this training over here, boom, you may have an employee. Independent contractors, they have to hire their own assistant. For close questions, make certain you're consulting legal advice or study up on them by reading about IRS advice rulings on Form SSA. So look in that aspect over there. Defining the employer, it really comes down to compliance. Understand all the inherent difficulties and consequences of workers' classification, and then a written agreement upon classification is necessary. Sometimes you may need to go back, and if you have somebody working in your area, just review their status as to where they are. If employment's contracted or contemplated at all, indicate its duration or at will, and it should be in writing, clear to everybody, so they can actually easily identify that right away without any questions, just in case you have somebody coming by from the government looking in your files and seeing who these people are. That's a big deal. Take care.